Good morning. It's September the 2nd, 2015. Welcome to Real Estate Tips. I'm Wayne Russell, instructor, broker associate with Freddie Mac Southwest, Sugar Land, Texas. Most of the information we discuss comes from realtors, newspaper articles, magazines, and emails from different sources. The material provided here is for information purposes only and is not intended and should not be considered as legal advice for your particular matter. Well, before we get started, I know y'all read the newspaper yesterday, but there was a couple on there that's eating this new ice cream that just came out. It's called Bluebell. I don't know if y'all tried it or not, but I'll tell you what. I was talking to Todd. He told me to save some. Nah.
You ate it all?
I ate it all. So, I mean, Todd, I'll save you some for the next time. And so, also, too, we have someone else that's sponsoring. Dr. Pepper is a friendly pepper-upper. It never lets you down. You can have it at 10, 2, and 4. But if you want something that's really good, put some ice cream in a glass, and then pour your Dr. Pepper on top of it, and you'll have a pepper float. Anyway,
nice.
It's those are the ones that are sponsored today. Anyway,
can I get some?
Yeah. So it's low-cal, almost. Anyway, we'll have some fun today. Just wanted to get on this outline that we're going to go over a few things. The latest about TREC form changes, sales contract provides final work on what stays and goes, who gets the money in this backup contract situation, title company errors need to be rectified and signed, can I execute documents in Louisiana for a Texas closing, Fannie Mae, Freddie Mac unveil new low-down payment plans, who gets a deposit at the tenant backside of the lease before the commencement date. I've had that situation come up, so we'll go over that in a little bit more in details. Mortgage lending, when to relist when the deal falls apart. Can you refuse to rent to smokers, smoother transaction with builders, and code of ethics. Now, one of the agents in our class always wanted to discuss the code of ethics, so we'll touch on that a little bit each time. Learn the latest about TREC form changes. The one at the recent meeting of the Texas Real Estate Commission took 2 actions to address the legislative requirements that will go into effect September 1st. Which was 2 days ago. The Commission adopted a revision on an emergency basis to the condominium resale certificate as required by Senate Bill 1168. The balance sheet of the Condominium Owners Association must be attached to the certificate. You know, when you're selling these condominiums or even single-family homes, you know, there's more to it than just getting the, there's the cost of the transfer fee that's usually in that addendum. But sometimes there's resale certificates, like in condominiums, there's certificate of compliance. And I've gone over it before on the certificate of compliance for the seller to provide a clean certificate of compliance with no provisions or no repairs. Now, the title company will issue title and close the transaction even if you have conditions in the certificate of compliance. So they don't care, but I mean, now the buyer is responsible for those repairs or conditions. So if you're in an area that needs to provide a certificate of compliance, in certain parts, even in First Colony, don't have to, and in some other areas that do. So if you might put in the contract that if required, a seller will provide a clean or clear certificate of compliance with no provisions or repairs. The updated certificate now states that the balance sheet is one of the 3 required attachments. In addition, the resale certificate must also provide details on fees associated with transfers of ownership. So you might want to check with the HOA to see what it costs for certificates of compliance and resale certificates, because only in that third party, you know, that addendum about you know, transfer fees, that only talks about, say, $250 to $300 unless you add something else in special provisions. Anyway, the revised form is mandatory for use starting September the 1st. Another law that becomes effective September 1st requires that all property owners, including commercial and selling real estate adjoining certain bodies of water like reservoirs or lakes, with a 5,000 acre feet or more water storage capacity, disclose to the buyers that the amount of water in the lake or reservoir could fluctuate. The TREC will post language on its website to satisfy the disclosure requirements. And license holders can add the language and special provisions of the contract when the seller is required to take the disclosure. Additional TREC forms changes discussed at the meeting or proposed changes will be open for comment soon. Anyway, if you're, I remember one time, about 2 years ago, I was up at Lake Conroe, and the canals of Lake Conroe were, you know, originally filled with water. So a lot of the buyers up there says, well, we're getting waterfront property, but through a canal. So we went up there and we had a drought, and the Lake Conroe was real low, and there was no water in the canals. And so there probably was some lawsuits that got involved, like, you know, we're supposed to have waterfront property and access to the lake, but they couldn't get their boats down the canal because there was no water in the canal. So they probably had some lawsuits, and that's why, you know, years ago you had 1-page contract, and today you only have 8 pages. On the leases, there's 16 pages. And here's the sample of the condominium resale certificate, and it's just the balance sheet right here. And on the top there, it's got the dates and then a balance sheet. And on the second page, it's got right in here on item O right there, it's got a little change right there, and it's down here, it's got a balance sheet. So anyway, when you're getting this information, selling the condo, you make sure that the condominium resale certificate will change just a little bit if you're selling condominiums. Just wanted to go over a couple of things. I'm kind of jumping a little bit here. I know y'all know the difference between detention and retention basins, or detention and retention ponds. The main difference between the detention and retention basin is whether or not it has permanent pool of water like a traditional pond. The water level is established by a low flow orifice. Most of the time the orifice is part of a metal or concrete structure called a riser. A detention pond or dry basin, in other words, if you see a, you know, kind of like a big hole in the ground next to a subdivision, and they've got one on the Southwest Freeway, they got them all over, so that you see it just a low spot. That's detention, because the water drains out. So remember, if it's dry, it's detention. With the bottom of the basin so that the water eventually drains out and remains dry between storms, hence a dry basin. The retention basin has the riser with an orifice at the higher point so that it retains permanent pool of water. You'll notice that a lot of areas have constant water with fountains and everything, and so that would be called a retention pond. So a lot of times when you're driving out with buyers and sellers, they go, hey, what's that over there? And I go, well, that's a detention pond. And one of them says, oh, no, that's a retention pond. So also in Riverstone, they've converted a detention pond, you know, into a dog park. I don't know if you've ever driven through. I think it's right off near Creekstone, one of the first subdivisions. They have a detention pond, and it's called a dog park. Okay, the next one is sales contract provides final word on what stays and goes. I want to go over this real careful. So anyway, when a property changes hand, what goes with it, unless otherwise stated in the sales contract, you'll find a comfy couch and a huge flat panel TV waiting for you when you move in. But about curtains, carpets, or mirrors, the question of what conveys is included with the property can be more complicated than you think. It's important that by the time whether the buyer or seller reach the closing table, you know exactly which items go on the moving truck and which ones stay behind. Here's how to know what's included or excluded in the sale. Of course, I could read the rest of that, and now I'm going to let you read the rest of this article on your own, but I wanted to get to the 1 to 4 family contract right here. I'm on this page right here. It's the very page 1. And when you go out and get listings, a lot of this wording's in the listing contract, but when at the very end, I think it's important for you to read this to your seller so they don't start taking things they're not supposed to take that's permanently attached. So, of course, item 2 is the property, the legal description, lot, block. If it's an acreage, it's usually a field note description. Improvements, B, the house, and you ought to read this to the seller to make sure that they don't take anything that they're not supposed to. The improvements, the house, garage, and other fixtures and improvements attached to the above described real property, including without limitation the following permanently and built-in items, if any. All equipment and appliances, balances, screens, shutters, awnings, wall-to-wall carpeting, mirrors, ceiling fans, attic fans, mailboxes, television antennas, mounts, and brackets for television and speakers. They can take the flat screen TV, but they need to leave the bracket and the wiring there. Don't be pulling out the wires from the walls. Just leave the bracket there. You might even use a non-addendum, non-realty addendum, and sell that flat screen to them for X dollars, or in lieu of repairs or something. Anyway, It says that the television antennas, mounts and brackets for television speakers, heating and air conditioning units, security and fire detection equipment, wiring, plumbing, and lighting fixtures, chandeliers, water softener systems, kitchen equipment, garage door openers, cleaning equipment, shrubbery, landscaping, and outdoor cooking equipment, and all other property owned by seller attached to the above described property. You know, a lot of times they'll start maybe taking out some things they, you know, one of their friends gave them a plant, you know, they planted something in the backyard and the buyer's expecting to keep it. So, I mean, if you don't exclude that in the contract and you start taking things away, you know, you may have a problem. This is important too. The following describe related accessories, if any: window air conditioning units, stove, fireplace screens, curtains and rods, blinds, window shades, draperies and rods, door keys, mailbox keys, above ground pool, swimming pool equipment, and maintenance accessories, artificial fireplace logs. I know that one time I was selling a house and they said, hey, I want to take my fireplace logs. Well, I better put it in the exclusions. You know, go ahead and put it in the exclusions. Fireplace logs and controls for garage door openers. In other words, when you come to the closing, make sure that the seller, if you have possession at closing, make sure the seller brings the remote controls for the garage door and keys for the house. Of course, the buyer should immediately get the keys changed out, you know, because I just think it's a safe idea. Anyway, garage door, entry gates, and other improvements and accessories, and exclusions. So write your exclusions down. One time, I listed a house and the seller said, well, my mother gave me this light fixture right here. It was just a regular light fixture, and it wasn't a big deal. She says, well, I want to exclude that from the sale of the property. So I excluded it in the listing, but I forgot to exclude it in the contract. So he says, so I was reading all this to him. He says, oh, by the way, remember, Wayne, I wanted to exclude it. And so I said, well, you know, I told you to remove that and put something else in there in lieu of your light fixture that your mother gave you. And so his wife says, well, Wayne asked you to remove that, but it never was removed. So guess what? Had to pay for it. So I gave him $200 and he was fine. So just watch yourself on the improvements built in. Now, some, like refrigerators, washers and dryers, are not included in this, probably in the sale, unless you have it in a non-realty item addendum, which is next. The non-realty item addendum. Now, most realtors use this right here on the, let's just say, a lot of times my sellers will say, you know, I'm going to throw in the washer, dryer, and refrigerator. And I say, well, you know, why don't you use that for a bargaining chip for repairs or something? And said, oh, that's a good idea. So anyway, use a non-realty item addendum. I've only had bill of sale come up one time. Robert, have you had any bills of sale in any of your commercials?
No.
Okay.
No.
Okay. So anyway.
So non-realty or inventory items.
Okay. Okay. I was just wondering, because a lot of times, you know, Robert deals in some commercial properties, and I've only had bill of sale come up one time, and the attorneys say it's best not to prepare those. And I go, so I just stick with what, you know, realtors have the addendum for, because the bill of sale, there's no promulgated or nothing. It's just a bill of sale. Anyway, let's get going on the next one. Who gets the money in this backup contract? Does my buyer client get her earnest money and option fee back if her contract with attached addendum for backup contract TAR 1909 never moves into the primary position? The earnest money is refunded to her, but the seller retains the option. Remember that your client retained the right to terminate the backup contract at any time while the backup position. So in other words, if you have a backup contract on a transaction, your buyer could lose the option money but get his earnest money back if, you know, the deal goes through with the primary buyer or the first buyer. And here's your addendum for a backup contract, TAR 1909, which is right here.
But you're saying if you're doing a backup contract,
Yes.
you still, at the time, you
Give them the earnest money and
earnest
option.
and the option.
Right.
And they're going to keep the option?
Yes.
If the deal goes through, they'll keep, if the
Yes.
original deal goes
Yes.
through?
Yes.
Really?
That's what it says. That's what it says. It says that, but the seller retains the option fee. And this is from TREC. So, anyway, National Association of Realtors, NAR.
Yeah.
Okay, The next one is material title company errors need to be rectified. I remember I was closing the deal and there was an attorney that was buying the house. Of course, you know, they have to get their 2 cents in, so they had refused to sign one of the addendums. You know, when you're buying a house with a loan involved, there's a stack of papers that you have to sign for the buyer. Usually the seller just signs the deed and a few other things in the closing statement, but the buyer usually has to sign a lot more because there's a note, deed of trust, and some other things. So he had refused to sign this one paper that the mortgage company and the title company wanted him to sign. So the closer didn't know what to do because we were in an impasse. So the closer called the attorney that prepared the paperwork. He says, "Hey, the buyer here is an attorney, and he says that he doesn't have to sign this piece of paper." Well, he says, we're all on the speaker. And he says, well, did he sign the paper that if there's any changes to be made in the contract or any changes be made in the paperwork that he could come back and sign again? He says, yes, he signed that paper. He says, okay, he didn't have to sign that other piece of paper. So the reason why I say that is because this is what happens in a situation like that. So anyway, it says, we just closed on the sale of our house and moved to our retirement community. The title company has called us and said we have to return to re-execute the documents. Because sometimes they make some typos. The title company does make mistakes from time to time. I have my money and don't want to risk another closing. Do I have to go back? The title company is used to file correction documents all the time. It typically involves misspelled names, typographical errors, and minor substantive errors. New legislation now has made this much more difficult. The title company has to determine whether the error is material or immaterial, and the remedy to resolve executing documents again. The statute controls this. Apparently your title company has deemed these errors to be material, and so you'll have to sign again. Take the day out of your well-deserved retirement and go sign. Let's see here. The next one is, I'm a Texas realtor. Many companies now are making up their own additional forms for sellers to sign, and it is the seller required to sign a form that is not promulgated form or forms made up by the various real estate companies. Now, I noticed that some of the real estate companies, and I won't mention their names, have additional paperwork in regards to, say, a seller's disclosure. And I was going to try to bring it to attention of the broker here, but we just seems to be missing each other. But you know, if you want to have some additional paperwork, I think that to have signed in addition to the seller's disclosure, you ought to discuss it with the broker here. The seller is not required to sign any form that don't want to sign. They may not be able to sell their house, though. A seller should ask each potential listing firm that what their policies are about signing forms. Each company reflects its own experiences and has its own policies and procedures. They can add anything to their contracts they want, so as long as it's legal. That's what competition is all about. Okay, the next one is, can I execute documents in Louisiana for a Texas closing? That says sure, but it's up to the title company to decide. In other words, most title companies want you to be present at the title company so they can see who you are, bring in your picture ID like a driver's license or a passport. And so I've closed deals where one of the owners didn't have a driver's license. She just didn't want to drive anymore, so she had to bring in a picture ID and then she had to get a passport. So make sure that when your buyers are coming in and sellers are coming in, that they provide the title company with social security numbers and driver's license. You know, and so you don't have to bring in your social security card, just know your number. Okay, let's see. I signed a contract to sell my house. The buyer gave me a cashier's check for earnest money drawn on the bank. In his hometown of Atlanta, Georgia, it bounced. Can a cashier's check be bad? Well, obviously it can. So, I mean, be careful where you accept these checks, and try to use a local bank when you're receiving earnest money and/or option money. The next one is, I'm purchasing a house. My credit was approved by the lender. I'm ready to close. My lender called me 2 days before closing. This never does happen to you. But I tell you what, there's one thing I don't like when I'm closing a deal in the day of, like if it's the morning of or the afternoon, I don't like to get calls from the title company saying we have a problem. Tom Hanks can do that in one of his movies, We Have a Problem, Houston, but I don't want to have any calls. So no news is good news prior to closing. Anyway, my lender called me 2 days before closing and said if you'll take another week to get my loan processed. The seller has a backup offer at a higher price and said I am in default and wants me to forfeit the earnest money and terminate the contract. What can I do? Well, when you sign a contract with the seller, you've already clouded his title. And so if you really want to get, if you really want to hold him feet to the fire, you just can file a les pendens or you can file the contract. But they won't be able to close it, this title company. Let's just say it's across the freeway here. They won't be able to close it if you have an existing contract because they've clouded the title. So the best thing to do is just get a full release of it, one way or the other. The longer you delay on getting that release of earnest money, whether the title company is giving the check to the buyer or seller, the longer the seller can't sell his property because it's been clouded. This is not a new issue with new lending institution regulations imposed by the federal government. It takes most lenders longer to process loans, especially after October the 3rd, that we're going to be faced with 60-day closings and maybe 90-day closings. So I mean, and then you have when it says clear to close, that means clear to close plus 3 days. Anyway, it takes the lenders longer to process the loans. The lender is really at fault here, but you probably don't have anything in writing from your lender, so their negligence or outright lie will be hard to prove. If you want to push harder, you can. Sue the seller for specific performance. Pleading time is not an essence, and a minor delay in closing is not your fault, so it doesn't create a default. As always, the legal alternative is more expensive, but may save the deal. We suggest the potential buyers always get something in writing from your lender if you can. If the lender won't commit, try another lender. So anyway, a lot of lenders are probably going out of business because of the Consumer Finance Protection Bureau. They're putting in so many restrictions, so the small guys will probably phase out. So anyway. I just put my house on the market, planning for retirement. I got 5 offers the next day. Did I ask too little? How do you respond to this information? It's a long article, but a lot of times in certain areas where there's a strong demand, you've got 10 or 15 buyers for one house. This will happen. A lot of times the house will go on the market and you'll have 10 offers in one weekend. And you have to make a decision where you want the maximum price subject to financing, or do you want a little less price for cash? So if it's a difference of $4,000 or $5,000 and you got a cash buyer and they have proof of funds, you might consider taking a cash buyer over the term buyer, but that's strictly up to whatever you want to do. It's your own personal decision. Okay, next is Fannie Mae and Freddie Mac unveil new low down payment plans. In other words, you're going from 3.5 to 3. But anyway, I heard a Sharp Radio report the other day that more banks are going to start offering mortgages that require a down payment of 3%. This would be great for me because my credit score is good and my income is steady, but I don't have a lot of savings because so much of my take-home pay is eaten up by my rent. Do you have any details about these programs? Well, they got a 3% program. The Fannie Mae and Freddie Mac, there are 2 quasi-government agencies. They play a key role in the nation's housing market. They don't loan money directly to borrowers, but instead purchase existing mortgages from lenders, pool them, and they sell shares in those pools to investors. Today, Fannie Mae and Freddie Mac own about half of all the mortgages in the United States. How do the new 30% down payment plan works? You have to have a credit score of 640. You have to be a first-time home buyer and not own a home in the last 3 years. Both say the loans can be used to buy a single-family home or a condo that can be used as the borrower's principal residence. And both will require the private mortgage insurance. So anyway, just if you're working with buyers, that's just another source. If they're just a little short on money, you might go that route. The next one, who gets the deposit at the tenant backs out of the lease before the commencement date. One of the agents in our office asked me about that. Their son had put up some money for deposit for rent, and I've had that situation come up before in Sugar Land here in Lakefield. The tenant, well, he had some personal problems, but anyway, he put up, I said, well, you know, your credit scores are not so good. You need to put up the first month, the last month, and a deposit. And say the rent was $1,500, so he put up $4,500. And so, and then just before the commencement date, he said, you know, Wayne, we've resolved our problems. It was personal. I won't go into details. And he says, I won't need to rent that house. I said, oh, okay. So I called the owner and said, he no longer wants your house to rent. So she says, well, I'll let him out of the lease. You know, I could have filed the lease and affected his credit somehow, but she says, well, if he cancels, I mean, if he signs a piece of paper saying he's not going to pay the rent anymore, but he's going to forfeit what he's put up, then we'll go along with that. So he signed, you know, I sent him an email and he signed it saying that he's going to forfeit his first month's deposit, the last month, and I mean the first month of rent, the last month, and the deposit, $4,500. And so we no longer will push him to pay the rent. So he's out of the picture. So I mean, every deal is different. That's how I handle that one. So you can handle your deals any way you want to. But anyway, let me read this real quick. The tenant for a property I manage entered into a lease with the landlord and paid security deposit first month's rent the day before the date of the lease period began, the day before. The tenant notified me that he had changed his mind and no longer wanted to rent the property. The tenant asked me to send the security deposit and first month's rent to his new address. But the landlord wants to keep the funds. Can the landlord do this? Maybe. This landlord has an obligation to secure a satisfactory replacement. It says that the landlord has the obligation to secure a satisfactory replacement tenant. The tenant may also attempt to locate a replacement tenant. If satisfactory replacement tenant can move in by the lease's commencement date, well, how about if it's the day before? You know, you give notice the day before. How are you going to find a replacement tenant the day before the commencement date? So, I mean, how about if the landlord can't and the tenant can't? Anyway, the landlord may hold the tenant in default and exercise the remedies in paragraph 27 of the residential lease. This may allow the landlord to keep the security deposit in the first month's rent. On the other hand, if the landlord does find a satisfactory replacement tenant who can move in by the commencement date, the landlord may only deduct from the security deposit in the first month's rent either a sum agreed to in the lease as a cancellation fee or actual expenses incurred by the landlord in securing the replacement tenant. Well, the landlord can say, well, it cost me X number of dollars, and you know, it equates to your first month's rent and deposit. So I would say that the owner will probably end up keeping that money. But anyway, that's what lawyers are for. Look at the debt to income ratios in mortgage lending. I just wanted to go over this real quick. Like let's see, I've heard most lenders will allow a borrower to have a 28% debt income ratio in order to qualify for a home. And I just underlined the main part. This 28%, often referred to as a housing to income ratio or front end ratio, includes the monthly loan payment, real estate taxes, homeowners insurance, mortgage insurance, and association fee for condo or townhouse owners. What is the 36% debt to income ratio? The lender may tell you that the income qualifying ratios are 36. The 28 refers to that of 28% of your gross monthly income that goes towards housing expenses. The 36 refers to that 36% of your gross monthly income that can go toward all your monthly debt, including the housing debt. But anyway, you know, in your mortgages, you probably don't get into that too much, but you know, upstairs we have a mortgage company, and you know, they'll pull up your credit report, and sometimes the credit scores are too low, and they'll say they may have to wait. So you can use any loan officer you want to. Went to relist when the deal falls apart. My seller contract didn't close by the date specified in the contract. What happens all the time, because deals just get, you put in a certain date and it just I don't know, I guess about 50% of the deals don't close on the exact date it's supposed to close, it just happens. When a seller's contract didn't close on the date specified in the contract, he and the buyer blame each other, and both want earnest money. The contract isn't been terminated yet, but my client wants to put the property back on the market. What should I do? Well, if he puts it back on the market and you have an existing contract signed and you want to go to the same title company, you're going to have a problem, because the title company won't issue clear title because you haven't got that first contract released. It's release of earnest money. Have your client talk to your attorney about the legal liabilities of proceeding with a sale without the termination of the original contract. Remember, there are two ways to formally terminate a contract. Parties can agree to terminate and sign a document like the release of earnest money, TAR 1904, that releases both parties from further obligations under the contract, or a judge can order a contract termination. So try to get that termination, a release of earnest money signed so that you can go forward on something else. Can you refuse to rent to smokers? I manage rental properties for a client who doesn't want people smoking on the property. If we deny a potential tenant's application because he or she smokes, will this violate any federal housing laws? No. And a lot of times in MLS you'll notice that no smokers, no pets, no smokers, no pets, no smokers, pet. So let's see, it's case by case basis. Thank you very much. Notice those things especially, and then ask when you're talking to different people that are interested in renting, that do they have pets? Well, knock out the ones that says no pets, and then here's the ones that could. Now, sometimes they'll take the small pets, but they won't take a big pet. But from time to time, they'll take anyone, as long as you put up enough money, well, they may take your pet. But anyway,
Sometimes they won't take certain breeds.
that's true. You know, they may not take the Great Dane or something because they just, you know. So anyway, or maybe a Chihuahua, I don't know. But I handle a couple of properties for and manage, and I say no pets, no smokers, and on the rents I pay. Tell them to pay me in cashier's check or money orders, no checks. Okay, when you're dealing with new construction, like I know someone that's trying to right now. I don't think his first name is Todd, but I won't mention any names. You're dealing in new construction, that you ought to have certain things that would make it easier and a smoother transaction with builders. Ask the builder which contracts they use. Well, a lot of the contracts that they use are a lot different from the 1 to 4 family that we use. So I mean, you might want to read it, but they can make changes in the contract depending on the supplies that they have. Sometimes I've had a buyer wanting the certain windows in the house that folds out so they can clean both sides of a 2-story house, and they said they were going to have that for them, but when they started building the house, they just happened to run out of those certain windows. So they had an out clause in their contract so that they didn't put in those special windows, and the buyer was a little upset, so I think they gave him some kind of allowances or something, and they went ahead and consummated the sale, but the buyer wanted the certain windows, but they didn't get it. Use the registration agreement between broker, which is attached here in case you want to register the buyer between the broker and the owner. But that's at 2401, which is here, and you might use that. Sometimes you can go to the builder and they'll prepare a registration to protect your buyer. Register with the builder. Remember MLS rules. Sometimes the builder will put on certain houses that are in MLS, but let's just say you wanted to buy a house that's not MLS. So it states down here, some builders act as listing brokers and list model homes in MLS, but the buyer chooses a home that's not listed in MLS. The agent may not receive a commission. Strong says this is the type of situation where it's key to have a written agreement with the builder from the start. So in other words, how about dirt? You know, there's a lot of times you go out and buy dirt and you have the house built 6 months later. It's probably not in MLS. So make sure you get protection from the builder. They ask money questions up front. How much do they pay for referrals or commissions? In other words, sometimes they'll pay 3%. Sometimes they'll pay, I've had it down to low as a half point. So I mean, read what your compensation is in the MLS. I know one of the agents in our office said, "Hey, Wayne, we're getting 5% on a new construction. I go, you better look where that decimal point is. It was 0.5. So he called the builder, and I think he got lost on the way to show the house. Anyway, it was only a half a point. So most of your builders will probably pay 3, and some pay BTSA, which is a bonus to selling agent, from say 1,000 to 5,000, as much as 10,000. Get it in writing. A builder agrees to compensation arrangement verbally, but make sure you get it in writing. Pre-qualify your client. Builders love a pre-qualified buyer. Sometimes your builders would want you to use their loan officer or their mortgage company. They own the mortgage company, they own the title company, and they want you to use their, their companies, their title companies. They want to use their mortgage companies because they want to control the buyer. So anyway, you can shop around for the interest rate. You can check, and then of course the builders will probably give incentives to the buyer, like pay X number of dollars for closing costs, or throw in some extras, some upgrades if you use their lender. And of course, here's your registration. And Marcy, whoever wants to send me information from time to time, I always try to acknowledge it in the class, but Marcy sent me this, and I'll just go ahead and quick read it. It says, what slowed down home sales keep rising even though all prices fall. New record set in Houston. July was the strongest month ever for home sales in Houston as local housing market defied predictions of slowdown and fallout from the declining energy industry. A total of 8,147 single-family homes were sold in July, the first time more than 8,000 homes have been sold in a single month. The Houston Association of Realtors reports, in fact, home sales have cracked the 7,000 sales mark only a few times over the years. I'll let you read the rest in the second page on your own. And now the Code of Ethics, one of the agents in our class wanted me to always cover the Code of Ethics from time to time, so that's kind of the tail end. Lessons 3 and 4, quick review quiz. The preamble to the Code of Ethics is an aspirational introduction to the code, which sets ideas that realtors strive to meet. True, the phrase "under all is the land" is in the first sentence of the preamble. It indicates all encompassing nature of the real estate business, embodies the idea that land is the foundation of food and shelter. It's all the above. And the preamble cannot be used to discipline a realtor. 3 major categories of the code are duties to realtors, duties to clients and customers, and duties to the public. Articles of the code are cited when a realtor is alleged to have violated the code, are broad statements of ethical principles, supported, interpreted, and amplified by standards of practice, all of the above. A member can be sanctioned by violating the pathways of professionalism. I have false. Anyway, the enforcement of Code of Ethics, the measuring process is known as enforcement of the Code of Ethics. Enforcement of the Code of Ethics, all 3 levels of a realtor organization have different roles in adoption, maintenance, and enforcement of the code. The Code of Ethics is enforced primarily by a local association of realtors. If a complaint alleging a violation of the code is filed, it's usually processed through the local association. National Association of Realtors, it says, some state association of realtors process complaints on behalf of associations by agreement with local association. If no agreement exists between the state association and the local association, the state association may receive and resolve the complaint reported from a local association which does not believe it can fairly resolve the complaint. For this course, we will assume that the local board or association of realtors process ethics and complaints and conducts of all the enforcement activities. Ethics or arbitration. One of the first things to understand about the code enforcement is there's 2 types of complaints which may become to association. We use the word association to mean any local board or association. And one type of complaint is in the ethics complaint, as you might suspect. Ethics complaint deal with questions of whether a realtor has violated one or more of the articles of the code. You might think of this type of complaint as a conduct complaint. The other type of complaint is arbitration request. Under our membership agreements of Article 17 of the Code, we as realtors arbitrate monetary disputes with realtors in different firms instead of litigating, so this second type of complaint might be viewed as money complaint. It should be noted that the realtors are increasingly relying on mediation to resolve complaints that in the past would have been arbitrated. Anyway, that's about it for right now, and And I really appreciate you all coming to class, and we'll see you in a couple of weeks. Thank you very much.
And thank you for the Bluebell coupons you're giving us
Right.
after.
Sure, no problem. Hold your breath.